I'm going to have to be slightly more than vaguely accurate today because I don't want to get sued. So before I start, I'll say I'm putting a link in the description to a particular judgment from a court case, and I need you to read that in association with this video. Right, hopefully that's covered everything. What am I talking about? Basically, why you should never sue for defamation. I get this a lot because I mainly do defence side defamation, but people will come to me and say, right, I've got a case, I want to sue for defamation. No, you don't. What? No, you don't. I haven't told you what it is yet. I know, but you still don't want to sue for defamation. I mean, realistically, unless you actually have absolutely nothing to lose, things can't get any worse. Nothing ever gets better by suing for defamation, and let me explain why. This is going to be an interesting one because I'm really going to have to use some euphemisms to get around the algorithm. But anyway, a particular person, he got in a row in a pub, and somebody allegedly said to him, "You're a," and it's the P word, but it's the abbreviated P word, and that will become very relevant shortly. So what word am I saying? It rhymes with those very tight swimming trunks that are very popular in Australia and elsewhere. So there you go. So you can hopefully figure this out for yourself. So this was said in a pub, and he brought a claim for defamation. He acted without lawyers, and as the judge said, he'd clearly done a lot of research. He'd spent a lot of time on this. He was quoting all the relevant authorities. But this is a very interesting case because this is one of those things where a judge had clearly decided who he thought should win, and then appears to have rationalised that decision. I'm not criticising the judge at all because I think the decision ultimately was the correct one, but it was very, very interesting. And to give you a little aside on this, I was around when they introduced the Human Rights Act, and one of the things the Human Rights Act introduced was that judges and decision makers had to give open reasons for their decision. Before the Human Rights Act, the judge just really had to just say, you win, you lose. I mean, you would get big full judgments in the Court of Appeal, but at first instance, judges would just say, you're the winner, you're the loser. They didn't have to give reasons. And a lot of my judge friends were complaining, going, look, I always come to the right decision, just not always for the right reasons. So they found it very difficult because when you have to sit down and rationalise everything and explain why you came to a decision, it can get quite tricky. But in this particular case, so he brings this claim, and it was against a lady. What actually happened was, this lady had a young daughter, an overage daughter, but with particular mental vulnerabilities that effectively, in some ways, she was as a child. And the evidence was that this guy had been inappropriately hitting on her, to put it mildly. And it came out at trial that he had said about this lass, he'd called her a, how can I put this, a Rick please, and again, that's just rhyming, at which point her mum turned around and said, you shouldn't be hanging around with, hitting on girls like this, the offensive word. So he sued for that. But here's the danger. When you sue for defamation, all your dirty laundry gets aired in public. So he had called two witnesses to support, because one of the first issues was, because this was slander, this was spoken, you have to evidence the exact words that were used. So he put on the claim form, these were the words that were used. And he actually said he was going to call two witnesses to support that, but they didn't turn up at trial. One of them said his dad was on long-term illness, and the other person said that he was busy at work. And as the judge said, well, that's hardly a justification, because, this has been going on for ages. These are like, it's not something that's suddenly arisen. It was your job to make sure your witnesses get to court. And he said, well, I thought they were coming. So he applied to put the statements in as hearsay. Now, the actual lady didn't object, but the judge allowed them in then. He said, well, arguably these shouldn't have gone in, but there's no objection, I'm going to put them in. But how much weight I give to these statements, bearing in mind they can't be tested in cross-examination, that's a matter for me. And ultimately he put no weight on them whatsoever. He said he didn't need to hear them. They didn't actually add anything, because there wasn't really a dispute that this had been said. There was a dispute as to how many people heard it. He also claimed that he had suffered, because you have to show that you've suffered serious harm as a result of the defamation. That's particularly the case with slander. You have to show special damages. You have to show, slander is not actionable per se, as we say. Defamation used to be, if somebody put something in a permanent form, such as writing or a television programme, you didn't actually have to show that you'd suffered harm. It was just implied. But since a case called Robertshaw, they've now said you actually have to show serious harm or a tendency, and you have to evidence it. And this is going to become very relevant, because I want to also talk about Laurence Fox's latest legal skirmishing. And funnily enough, I'd planned this video, and I was going to mention Laurence Fox, and then just as I'd planned this, he got his leave to appeal. And this is all going to become very relevant, because Laurence Fox featured in this particular case. So the evidence comes out. What they actually said was, well, look, this is a guy who's going around sort of, bragging to people. He spent the last year in the pubs going, I'm going to ruin that woman. And, he was actually putting out there, all the details about this case. So they said, well, how have you suffered serious harm? And he said, oh, my family are shunning me and avoiding me because they think, I'm inappropriate with young girls. But part of the problem was, this is very, very split. There were all the guys in the pub were going, well, not going, but they're saying all the guys that quite liked him. He was the life and soul of the party. He would hug people. But all the women were going, no, he just hits on everybody. He's a real creep. And this is part of the problem, because all this evidence came out about what a terrible person he was, according to the evidence, not according to me. Also, he'd been sending inappropriate Facebook messages, allegedly. Now, they didn't go in at trial. There were some that went in up to a certain course where he was clearly, trying to ask her out on dates and putting out how much he fancied her and things like that, that were perhaps like a bit creepy, that hadn't sort of crossed the line into, going too far and too suggestive. But what the mother said was, well, my daughter has now had to have therapy as a result of this, because he's been harassing her for years and always hitting on her. And her therapist advised her that she should delete the text and just have nothing to do. Just block him, delete everything. It's just going to re-traumatise you. And he said, well, this can't be right. I want to put in evidence, here you go, that therapists would never, ever tell anybody to do that. But the judge turned around and said, well, notwithstanding what therapists tell people to do or not, the fact of the matter is you've got the other side of those texts. You've still got those messages, and I notice you've not put them in either. So I will infer from the fact that you have not put them in that there's something that you don't want me to see. So, like I said, everything went in on this. But the interesting thing is, we had what we call the meaning hearing. And just in case you're not familiar with that, in defamation, one of the things that a judge has to decide was what was the actual meaning of the defamatory statement, because it has to sort of, hit the test to cause people to shun and avoid you or lower your reputation in the minds of right-minded people. So he said, let's assume that she actually used that word and that abbreviation. Well, he said, well, look, relying on the Blake and Fox case, that's the Laurence Fox one, where he had accused people, but he'd used the full word. The judge there said, well, clearly these allegations are very serious because they amount to an allegation of a serious crime. And an allegation of a serious crime is usually deemed to cause serious harm. I said, but in this particular case, you've got to look at the context. This was a very fast-moving situation. She was saying this in response to an insult he'd said about her daughter. And he said, would your average right-minded person think that that word, the shortened version of the word, was synonymous with the long version of the word? Now, I'd be very interested to hear your comments here, because I must confess, in my humble opinion, I would have said, yeah, they are pretty much equated. People might bandy it around as an insult generally and not actually mean it, but I don't think there's any real difference there between the abbreviated version of the word and the longer version of the word. Interestingly, something that also cropped up with those two statements that the judge was very suspect about was the fact that the guy had capitalised, in all the statements, they'd capitalised certain words. And he said, did you write these statements? And he said, well, no, I helped them write their statements. And that's another thing. When you sign a witness statement, you sign that it's, your own words and everything in there is true, but the own words thing is very important. And the fastest way to get your witness statement excluded or disregarded is to say somebody else wrote it for me. I mean, this crops up in like big high-profile litigation. You know, did you write this statement, or did your lawyer write it for you? My lawyer wrote it for me. Right, Your Honour, yeah, absolutely, I'm not going to put any weight on it whatsoever, because it says, it's got to be in your own words. So that was another factor that came in. But what the judge here said was, I think your average reasonable person wouldn't equate the short version with the long version. It's just an insult. We're back to the Elon Musk thing when he had to go at those people who rescued the kids trapped in the cave. So it's very interesting. So he lost. He actually lost on just about every ground. The judge said, you've not shown serious harm. The meaning isn't defamatory. I'm not convinced that anybody actually heard it anyway, but for you two sort of, shouting at each other. But all this stuff came out where it came out that he'd been throwing glasses at people, women, like, and he's going, no, I didn't. I just threw my beer over her. The glass, it was an accident, and it slipped out of my hand on several occasions because, like, a couple of women came forward and said this had happened. He also said because he claimed that she was biased because she'd said he'd been arrested, and he said, no. The police came and hauled me out of the pub outside, but ultimately they didn't arrest me. And the judge said, well, you know what, to the untrained observer, the police dragging you outside, like out of the pub after you've been kicking off and like throwing glasses at people, I'm not going to sort of hold it against them that they didn't, realise what the technical definition of an arrest is. So what ultimately happened? Well, he lost his case. Now, as it happened, normally you'd get hammered with costs with this one, but the lady, she was unrepresented. If you are acting on your own behalf, you can claim a massive £19 per hour. I'm being stalked by the Coast Guard again in a helicopter. You can claim £19 per hour plus any disbursements you make, like photocopying costs. But what this lady said, she says, look, I just want the end of this. I'm not bothered about the costs. I just want him to go away and not harass my daughter again. So there you go. So like I say, read the judgment and see what you think of him. And do you think it was wise of him to bring this up? Because it'd be interesting to see if he's still going around in the pubs bragging about the court case and saying, hey everybody, here's what happened. But anyway, the Lawrence Fox thing, because like I say, he said in there, he referred to the facts and said, in the Lawrence Fox case, the judge said an accusation of the P word is clearly defamatory. But what's very interesting is Lawrence Fox has now been given leave to appeal. Now, I've not seen the grounds of appeal, I've just seen the notice giving leave. And what's very interesting is, as a lawyer, you can read between the lines. I mean, the first thing is, it's fairly clear that they threw the kitchen sink at this appeal, because the judge has sort of said, I've dismissed some of the grounds of appeal. I'm allowing things to go through on this. And he said, basically, you've raised some points. In the grand scheme of things, I'm going to let them go forward. But really narrow down your arguments. Think about what's important, people here, because I've listed it for 1 day, which is quite a short time limit for an appeal. But he's been allowed to appeal both the dismissal of his counterclaim and the fact that some of the claims against him were successful. And it's all hinging on the serious harm bit. So it's going to be interesting because, like I say, I think the judge in the case was just talking about really tweaked the language and really pushed the envelope on the meaning of that word. And it's going to be interesting to see whether the court of appeal say it shouldn't be an automatic thing. You have to show serious harm, you have to show loss. Now, I think in that particular case there probably was, because, like I say, people were Googling the names of some of these people, and unfortunately they shared their names with people who had actually been convicted of relevant offences. So people are going, well, it's obviously them. Now, the other interesting thing in the notice is the courts refer to 2 cases. One's a relatively recent Australian case that's all about serious harm that I personally don't think adds much to the key case here, which is called Le Show. There's another old case called Williams, which is from 1986, actually. And again, what I find interesting is, because I've not seen the grounds of appeal, so I don't know why these cases are relevant. It's interesting that they've cited and said, please especially bear in mind this Australian case. I am just wondering if the court is using this appeal as a way of saying, actually, this Australian case sets out things quite nice and neatly. So we'd like people to refer to that in future when they're doing sort of defamation cases on this point. So we want to adopt it because while foreign judgments are not binding on English courts, they can be what we call persuasive. In other words, you say, look, we're having a particular argument here. Some other people in a country that uses a very similar legal system, a shout out to all my Australian law friends with your, is it about 8 different legal systems you've got over there at the moment? Considering we all share a common heritage, it's very interesting just how different they all are. But I'm just wondering if this is a backdoor way of saying, actually, this is a really nice case. I mean, it is a very good judgment. It's almost like written like a textbook, you know, if you actually want to sort of learn about sort of defamation and serious harm. It is in fact a very, very good judgment. So maybe the judge just wants it. So now in future people can say, well, obviously the Australian case has been incorporated into English law. And why my big thing at the beginning saying about looking at the judgment? Because there's a thing called bane and antidote, okay? Which is, in the old days when you had like newspaper headlines and it says something like, Gary Oldman is a terrorist. And then when you actually read a bit further down, it'll say, you know, in the fantastic new film Air Force One. The argument is that you can't look at defamation in isolation. You have to take the whole the whole thing that has been published. So, you know, the bane is, that's a horrible sting, and that's clearly, a not very nice thing to say about people, and if that's true, I would shun and avoid them. Oh, but now I've actually read the full story, I realise that headline was a bit of an exaggeration. I mean, considering people didn't actually have to buy the newspapers, you'd be walking past the Evening Standard stall, or the newsagents, arguably that's quite a harsh test, because how many people would read everything? But the same applies online now. And what the courts say is, you've got to take everything. So if somebody does like a tweet, but then links and says, for more details, see here, they assume you will go and look at the rest of it, even if you won't. However, if people have to do that research themselves, you don't point it out to them and highlight where they can find the backstory to this. Then the court just says, no, we don't expect people to do their own research. You are just taken on what you personally published, and if that's just the defamatory bit, even if actually the full story explains what you mean and it's not defamatory, tough, that's on you. It's for you to link to it. And this gets all very complicated in the days of Twitter, where people are replying to tweets and quoting tweets and things like that. You know, how far do you expect people to go? I mean, this cops up a little bit where people don't name people. And if you notice, I've not named the guy. You can find his name in the full judgment, but I've made sure that there is no bane here because I've not said anything about anything. But even if I had, I would be entitled to say, I've invited people to read the full judgment, and that explains the full thing. And one thing that cannot be defamatory, you have a defence, is fair and accurate reporting of court proceedings. And notice this is fair and accurate, not vaguely fair and vaguely accurate, which is for once why I'm saying go read it for yourselves. But yeah, I'll follow the Lawrence Fox thing. I mean, it'd be nice if I could see the grounds, because I could actually give you more detail. So it's all a bit mysterious at the moment. I have to read between the lines. But we shall see what happens. Well, anyway, as always, hope you found that vaguely interesting, vaguely useful, absolutely spot on and perfectly accurate. And I'll see you next time.